So finally, part 2 of the Drake petitions. I got a little under the weather and I'm rethinking how I want to do this YouTube channel. Ultimately, I want this channel to empower more people to understand legal concepts and read primary documents themselves instead of relying on unresearched and incendiary commentary to form an opinion. So here goes, part 2. This video, I'm going to stick to a script and hopefully this leads to a more succinct exploration into the Texas petition. With that being said, this video is going to be less an examination of the Texas petition, as the Texas petition is very much a repetition of the New York petition, and more about key legal concepts that are going to be relevant should further action be pursued in regards to both defamation and fraud claims. So, an overview of the Texas petition. The Texas petition is described as a quote-unquote defamation suit, but it is not a petition that is requesting information in order to file a defamation suit. It basically alleges the same conspiracy claims in the New York petition, except instead of UMG conspiring with Spotify, UMG is conspiring with iHeartMedia. In essence, what Drake is alleging is that due to iHeartMedia's reach to 9 out of 10 Americans, they are vital to the conspiracy of artificially inflating the popularity of Not Like Us. Paragraph 13 makes clear that Drake does not have the same evidence of the collusion between UMG and iHeartRadio that he does for Spotify. But he intends to determine whether there are claims through the depositions he is requesting from the court. Paragraph 13 of the Texas petition states, petitioner has been unable to confirm whether any iHeartRadio stations were among the stations paid as part of UMG's pay-to-play schemes, or whether they were any direct payments from UMG to iHeartRadio to promote Not Like Us. The only place where defamation comes up is in paragraph 17, where Drake claims that he intends to collect facts to file tortious claims, including claims for defamation, civil fraud, and racketeering against UMG and unidentified co-conspirators. And the paragraph 17 is on the screen, and it states, and I'm truncating it a bit, petitioner has amassed sufficient facts to pursue certain tortious claims against UMG, including, but not limited to, a claim for defamation, but currently lacks factual support necessary to determine whether he may bring claims of civil fraud and racketeering against UMG and its many, as of yet, unidentified co-conspirators who violated payola laws and accepted illicit payments and other things of value from UMG without disclosure. So, as I did with the New York petition, I'm going to review the elements. In reviewing the elements for a civil RICO and New York deceptive business practices, let's dive into the elements of a successful defamation claim. So, here's a short lesson on defamation. First, let's give some context. The statute of limitations on a defamation suit is a year. So if any claim proceeds, I believe the defamation suit in Texas is most likely to actually see a complaint filed in the near future. Moreover, they have all the information they need to proceed with the defamation claim as keyed in by this elements list. So let's go through the 4 elements of a defamation claim under Texas law. 1, the defendant has published a false statement. 2, that defamed the plaintiff. 3, that with the requisite degree of fault regarding the statement's truth. And 4, damages unless the statement constitutes defamation per se. So, per se defamation involves defamation that is defaming on its face and therefore there does not need to be proof of damages. If the defaming statement involves the commitment of a crime, then it is defamation per se. However, I think if Drake pursues defamation litigation, he is likely still going to itemize his economic damages anyway, as they are much higher than any statutory punitive damage award. So just to give context, I think there has been some rumor about that. Basically, one of the motivations behind these petitions is to influence UMG to renew Drake for a $600 million contract that is more than his original $400 million contract taken in around 2020 and 2021 with UMG. So basically, that's at least damages coming closer to around $200 million, which I think is far more than any damages that would come from statutory and punitive damages. So this is also to confirm the defamation per se does not impact the requisite degree of fault required to prove a defamation case. So let's go into element 3, which was the requisite degree of fault, and that depends on the public figure status of the plaintiff. Since Drake is a public figure, in order to have a successful defamation claim, he must prove that the defendant published the statement with actual malice, or reckless disregard for the truth, or reworded, acting with the knowledge that the statement was false. The primary defense is going to come from the actual malice element. To give an example of actual malice in a defamation suit against a public figure, we can look at the lawsuit Cardi B filed against Tasha K. Tasha K claimed in over 30 YouTube videos that Cardi B was a prostitute, used drugs, and contracted sexually transmitted diseases. All of these would be defamation per se, by the way, just making sure you're paying attention. The fact that Tasha K made these claims was not what caused her to be liable to Cardi B for defamation. What made Tasha K liable was the fact that she admitted to knowingly publishing lies about Cardi B. And here's an excerpt from an article from Billboard. Kebe, who is Tasha K, initially admitted that she knowingly published lies about the rapper, but later tried to walk back the statement when examined by her own attorneys. And if we were to go back, we could see that this would definitely fall under the actual malice of acting with knowledge that the statement was false. The fact that if Tasha K did not admit that she knew she was lying, she would likely not have been found liable for the defamation claim. This is why defamation claims brought by public figures are so hard to win. You hardly ever get a defendant like Tasha K who is bold enough to declare that they knew that their statement was false in 4K. So now let's get into some defamation defenses. This will be a little fun. I had a little fun with this. I was on my litigation bag. So if there are any lawyers watching, please tell me how you would try to defend this. Or if you're a law student or an aspiring law student, please consider how you might have come up with some defenses. So Drake definitely has an uphill battle to win a defamation suit against UMG for publishing Not Like Us. Moreover, unlike the Depp v. Heard case, where a social rejection of the effects of the Me Too movement mixed well with the non-sequestered jury, Drake does not have the public on his side. So here are some defenses that I think could be pursued if the defamation claim goes to trial. So first, distinguishing between the colloquial meaning of a word and the legal meaning of the word. So there are many words that we use that have distinct meanings from their dictionary or legal definition. For example, some may call someone a whore, but according to Merriam-Webster, the old-fashioned definition of a whore is a, quote, person who engaged in sex acts and especially sexual intercourse in exchange for pay. Most people, when using whore, or its now more common truncation, hoe, are not referring to a sex worker, but rather someone who is promiscuous and has sex with a lot of people. And for that reason, whore technically has two definitions, as you can see in Merriam-Webster, differentiating from its more technical definition and the colloquial definition that has arisen over time. Arguably, pedophile has entered the same type of semantic context as whore. The Merriam-Webster definition of pedophilia is a sexual perversion in which children are the preferred sexual object. However, colloquially, pedophile means an adult who has a tendency to surround themselves with underage individuals or who has entertained an attraction to an underage individual. Using this distinction and definition will help the defense establish that the truth is on their side when it comes to whether Drake is a pedophile in the colloquial sense as opposed to the legal sense. And I think that this is where a lot of people defend Drake adamantly, which is they say Drake could not be found guilty of pedophilia in the criminal court of law. And that's one of his main cases. And I think it'll be important for UMG's defense, and I'll talk about this later, likely Kendrick's defense as well, that they're not talking about any legitimate criminal, and more importantly, criminal legal claims of pedophilia, but rather in a more colloquial sense that is a little bit looser in its implications. So by using this definition, we could use truth, which is an affirmative defense in a defamation claim, as the first element of a defamation claim is publish a false statement. So if it is not false, you can use truth as an affirmative defense. So, using the aforementioned colloquial meaning of the term pedophile, there is plenty of evidence to prove that Drake has a tendency of surrounding himself with underage individuals, or has at minimum entertained an attraction to an underage individual. In What's the Dirt 616 in LA video, he finds video evidence of several incidents affirming that Drake invited underage girls to his private parties. There's also Drake's public relationships with an underage Millie Bobby Brown and Billie Eilish. At minimum, Drake meets the more colloquial meaning of quote unquote pedophile, and therefore Not Like Us is tethered to the truth, and there's no evidence of publishing a false claim. So the next part is context, which I actually don't think is that strong of a legal argument. I've seen a lot of people point this out, but as you could tell in the 4 elements of a defamation claim, there's no part of the claim where it's like, well, if you agreed to be defamed, then it's okay. But I do think context matters, and it will give either the jury or the judge, it depends on who's chosen to make the decision for a litigation of this kind. It will make it easier for a judge to determine what type of damages will be for Drake. So, for example, if a judge or a jury determines that Drake was sort of kind of liable because he joined into this beef voluntarily, then he can't be held liable. He can't recoup the $200 million because you took that risk when you decided to join a rap beef. So, context matters, and rap beefs are a unique spectacle where the intent of the participants is to deride the opponent to an extent where they can no longer respond with dignity. This would be the point where a defense attorney would watch an FD Signifier video and try to create a timeline of rap beefs and battles over time to show many examples of rappers using incendiary lyrics to beat their opponents. I would also try to connect rap battle to comedy roast, since unfortunately there are a lot of racist stigmas against rap, but there's more universal respect for entertainment genres like comedy, where roasts are commonplace. So the argument would be that Drake voluntarily participated in the rap battle, agreeing to the terms of precedent rap beefs with a nearly 50-year history to inform him of the potential claims that could be made against him. Moreover, he anticipated that an attack involving his relationship with minors, because in his second song in the rap battle, Taylor Made, he stated through the AI-generated voice of Tupac that Kendrick should talk about him liking young girls. That's a gift from me, making the case that the claims on Not Like Us were not made with reckless disregard for the truth either, because it is an accusation that many people believe, including to an extent Drake, understanding that this was a mainstream belief about him prior to the release of Not Like Us. And so the final point that I'm going to make is actual malice. And I think I'm sure several UMG executives have said to Drake's face that they don't believe he's an actual pedophile, which may be a reason why Drake feels so confident on a defamation claim. And I put this Mark Lamont Hill clip, and he was on the Joe Budden podcast, which apparently he's now kind of one of the rotating cast members, where, he was adamant that nobody actually really believes that Drake is a PDF file. And I'm sure that this is not something that Drake has just heard from Mark Lamont Hill, but also from many, many people, especially in UMG. However, his struggle will be connecting any executive who assured him that they know he is not a pedophile with those who were involved with the decision to publish Not Like Us. And my belief, I don't know what really goes on behind the scenes, but I suspect that particularly when this rap beef was going on, it was just a predetermined green light for the dropping of all these songs. Deal with copyright and all that stuff later, or I actually really don't know how songs are put down, but I'm suspecting that when Drake thinks about executives at UMG and them betraying him, he's probably talking about Lucien Grange and really high level people who quite frankly probably have no idea about the mechanics involved in actually publishing a song. So I just find it really interesting, because I do think he probably does have some evidence of executives saying, of course we don't think you're a pedophile. But then it's were any of these executives the ones who, as said in the defamation element claimant, someone who published that claim. And that would be kind of a defense. I would argue a weaker defense, but definitely a defense by any defendant in this case to say there's no connection between the individuals who said that we don't believe you are a PDF file and those who make the decisions to publish. Okay. So, in the next chapter, I will discuss why Kendrick Lamar will likely be a party in the defamation suit, and how Drake and his legal team are trying to preemptively distance themselves from the claim that Drake is suing Kendrick. Okay, so let's go into party politics. Okay. So one of the key distinctions between the two petitions is that unlike the New York petition, Drake himself is the petitioner in the Texas petition, as opposed to his LLC, Frozen Moments. When it comes to a defamation suit, it is important that the party that is defamed is the plaintiff, hence why Aubrey Drake Graham is the petitioner for the proposed defamation suit in Texas. I want to clarify any confusion about how parties are joined into lawsuits and why I believe Kendrick will be joined to at least the defamation suit. In paragraph 18 of the New York petition, Drake's counsel claims UMG has pointed the finger at Mr. Duckworth, Kendrick Lamar, insisted that Drake should initiate legal action against Mr. Duckworth rather than UMG, and even threatened to bring its own legal claims against Mr. Duckworth if Drake were to pursue claims against UMG. This sentence bothered me a bit because this felt like a public relations sentence intended to preemptively blame UMG for any instance in which Kendrick Lamar may be joined into the lawsuit. This would be important for Drake to establish because it would make him vulnerable to accusations that he's trying to bring the rap beef to the court, although clearly that's already happening. So I'm going to go into the nitty-gritty of stuff, but the TLDR before I get into that nitty-gritty is that Kendrick is likely a necessary party in the defamation action and will be joined into the claim if it proceeds to litigation. Okay. So, simply because a party is not named in any initial action, it doesn't mean that there aren't important reasons that they are either forced to join by the court or brought into the claim by another party. So, this next section is going to get into nitty-gritty. Warning you right now, this will not be that much fun. But if you ever had any idea of what law students do all day, this is actually a very small part, but this is a vital part of actually what law students learn in their first year of law school. So, in the rules of civil procedure, there's something called a required joiner. This is Rule 19 of the Federal Rules of Civil Procedure for all my law geeks out there. There are many ways a party can be joined to an already commenced action, but a required party is needed in order to proceed with litigation. To determine whether a party is required for a litigation, there are 3 questions that need to be asked. 1. Can the plaintiff here, Drake, acquire complete relief among the existing parties? 2. Will any party's legal interest be prejudiced by the absence of a party? And 3, would a present party be subject to multiple or inconsistent liability to the absence of a party? For all the aforementioned questions, the answer heavily relies on whether the state is joint and severally liable. Okay? I'm not going to do a deep dive into this concept, but essentially each state in the U.S. has different rules regarding how liability is distributed among multiple defendants in a claim. If the state has joint and several liability, it means that if one party is found liable, it is liable to pay for all the damages, even if it's only responsible for 20% of the damages. And a really high-level example is if you go to a restaurant, and even though you only ordered fries and a soda, you will still be liable for your friend's appetizer, alcoholic drink, entree, and dessert if you are on the same check. So, in regards to Texas and New York, they have modified joint and several liability. And I realized after I wrote this that this is not relevant, but I think this is just interesting stuff to hear and know, because you might hear these terms if you are trying to keep up with legal news. You might hear these terms jump out. So just giving like a high overview. So, the modified joint and several liability, which is relevant for Texas and New York, says that if the defendant's percentage of damage is less than 50%, then it is only responsible for its percentage of the damage. However, if a defendant comes under joint and several, a defendant comes under joint and several liability if the claim requires specific intent. Fraud claims are specific intent claims, and defamation against a public figure, which requires actual malice, is also a specific intent claim. So, In regards to question 3, whether a party is necessary, UMG and even a judge independently would likely determine that Kendrick is a necessary party. And this is because a present party, in this case UMG, would be subject to multiple or inconsistent liability due to the absence of a party, right? So yes, UMG published Not Like Us, but Kendrick was the one who came up with the lyrics. Kendrick was the one who stated them. And likely the process of publishing, it was just a normal process of publishing, and I'm sure even the judge could probably tell that it would be a really deep slippery slope if they started allowing recording labels to be made liable for publishing of these songs. And a lot of these artists, like, we can look at this rap beef and poo-poo it as this thing that, like, is kind of like just two egos butting against each other. But there's a lot of artists, particularly singers, who will sing about their abusers, who will sing about political actors who they disagree with, who will sing about just tragedies that happen across the world and potentially pointing a finger or inference in such. So if every time UMG, who's a massive entity who has multiple offices around the world, publish a song that may be deemed liable in the jurisdiction where that song is published, because I also want to remind everyone that US has actually one of the hardest defamation statutes in the world. Like, US does not play with their First Amendment, although they have been they've been tickling it a little bit recently, but for the most part, many other countries, this wouldn't even be a question. It would be like Kendrick would have already been made liable for this. So this would set a really dangerous precedent if recording companies could be found liable for these, and particularly also because recording companies are a lot wealthier than their artists. That goes without saying. So yeah, this could just lead to a very slippery slope that even Texas, Texas corporate loving Texas might also be like, this isn't looking like something we want to head into. So again, TLDR. In the claims Drake has brought against UMG, liability is joint and severally liable. Kendrick Lamar will likely be determined to be a necessary party, especially for the defamation claim, because the act of coming up with the lyrics of Not Like Us bears far more responsibility on the subsequent defamation than deciding to distribute the song. In regards to the potential New York claims of civil RICO and deceptive business practices, Kendrick likely has much less liability, but there's any claim of his personal liability of conspiring with UMG, he will also be deemed a necessary party. But I think more likely than not, at minimum, if the New York case moves forward, Kendrick and his crew will probably be at minimum witnesses. And I say that at minimum, but if you think about that paragraph in regards to the interviewee with academics, he claims that it was somebody from Kendrick's party that was the one really inciting him to use the bots. So what's next? All right. A judge in both New York and Texas will affirm requests for more information or deny the orders. There are two judicial systems here, so there will be scattered responses and different standards applied in each. And again, interjection, which I've been doing a lot of them throughout this video, but interjection. It really also just depends on what judge has this. There are going to be some judges that are music lovers, and their perspective of this, and they might not even be rap lovers, but they'll just be like, I remember when, some hunk old country player was really mad at this country player, and they went back and forth. It really all depends, and personal context matters, and that's one of the worst things to learn as anyone practicing law, is how much of this legal system that you learn is governed by rules, and you got to do it this way and that way can be bent so differently just based off of the preferences of the judges. So even if a judge affirms the petition's request and all the respondents provide the information in a timely manner, it will take time for Drake's legal counsel to determine whether they want to proceed with filing a complaint, right? So again, no complaint has actually been filed, no action has actually been started. All of these things are petitions to see if that they have further action. All right? I have no doubt that even if further litigation is not pursued beyond these petitions, if depositions or communications are collected by Drake's teams, some of them will quote unquote mysteriously be made available to the public. And I even have a small theory that this might also be just the end game. I don't know if litigation is the end game, but the end game may just be to try in any way, shape, or form embarrass UMG and anybody that they have depositions with. And I think that the point of this will be to just kind of burden the system a little bit, to put pressure on UMG, maybe to, I don't know what Drake's desire is. There have again been rumors that he wants to maintain a 600 million re-sign, or he wants to get out of his contract. So regardless, do not be surprised if either of these judges in either of these states affirmatively order that yes, he can collect these depositions, or yes, he can collect these communications, that these will be leaked to the general public. So I have no doubt about that. So finally, we'll see if you file complaints on any of the potential claims. So thank you for watching this video. I'll catch you in the next one. I think my next videos are going to be a little bit more fun, but if there's an interesting legal claim, I will come back to this. But right now, I think I'm not. But I think you'll see a review of Queer soon on my channel, and I'm really excited to be a little bit more relaxed and less formal. See you next time. This was Strategic Delusion.